678-42174. How you doing, Ms. Garion?
Good, Judge. Good to see you.
You too. What do we owe the pleasure of you coming in person?
I was told to come in person, so I follow directions. I don't know why. I'm special. Oh, you're right now.
Why did they tell you to come in person?
I don't know. And I even
Who'd
called.
you talk to?
The court notice says in person, and then I called earlier this week. I don't know.
Heather, do you know anything about that?
I do not, Judge. I'm looking at what case it is. Usually we put in person on the defendant's copy, but then if there's, oh no, and on these oh no, she's a pre-form. I usually send a Zoom form with these for the pre-formals with the retained attorney.
Yeah, what happened here? Well, I don't know what happened.
I'm here and it worked out and it's fine, Judge. Always good to see you.
You too.
All right, guys. Today we're going to witness a courtroom moment that starts calmly, but turns tense in seconds. At first, everything seems routine until the judge suddenly calls an attorney forward and makes it crystal clear that something is wrong. The atmosphere shifts instantly when he says he's not happy. That single line changes the entire energy of the courtroom, setting up a confrontation that immediately grabs everyone's attention.
I don't think you would have talked to my judicial clerk because I don't think she would have insisted that. I know she wouldn't have. Maybe you talked to one of the other staff and they thought you were a defendant. I don't know. But at any rate, my apologies. You're gonna plead to impeding your authorized enter that plea, correct? On behalf of your client?
That's correct.
To that charge, responsible or not responsible?
Responsible.
Plea is accepted, 150. I'll give them a week, okay?
Perfect. Thank you.
May 6th. Have a great day. Take care. Be careful out there. All that water on the roadway, right? Aaron. Justin Tyreek Heron. 26W841-783 A, B, and C. Okay, Mr. Heron, you can come on up here and tell me your name, please.
Justin Heron.
All right, so you met with the city attorney. You're going to plead guilty to allowing an unlicensed driver to drive. And they are then going to dismiss the They are then going to move to dismiss the driving on a suspended, no proof of insurance, and expired plate. True?
Correct, Your Honor.
And that's what you want to do?
Yes, Your Honor.
And apparently you have another ticket you're going to pay today, right?
I'm on a payment plan. I just made a payment for the.
Okay. If you plead guilty to allowing an unlicensed driver to drive, I'm going to dismiss all other charges. The possible penalties are up to 500 fines, 90 days jail. Costs are all those. Do you understand that?
Yes, Your Honor.
You just sign, read, and understand the advice of rights.
Yes, Your
You
Honor.
plead guilty, you will be giving up all those rights, and we're not going to have a trial. Do you understand that?
Yes, Your Honor.
You still have the right to a lawyer. If you want one, I'll give you one. Do you understand that?
Yes.
Would you like a lawyer?
No, thank you, Your Honor.
To the charge allowing an unlicensed driver to drive, how do you plead?
Good.
On the 7th of March of 26, were you in control of a 2011 Ford that was being operated on Western Island and Woodhaven?
Yes, Your
You
Honor.
allow somebody to drive that was unlicensed,
Yes.
and that was you, right?
Yes.
Are you on probation or parole?
No.
Anybody force you to plead guilty?
No.
And you're still suspended, right?
Yeah.
Please accept it. The suspends, dismissed, no proof of insurance, and expired plate are dismissed. You got to stop doing this, son.
No, Your Honor.
100 fines, 150 costs, 75 victims' rights, $50 justice assessment. I'll go kind of light, but 375 or 90 days. Do you have all that to pay?
375.
Or 90 days?
I can start. I got a payment plan on the 272 for those weekends. So can I put them together for a payment plan?
When are you supposed to pay and how much on
I
those?
just paid today. Another payment. I'm supposed to pay 55 a month.
Yeah, Judge, his payment plan on his other tickets is $55 monthly. He did make a payment today on that.
I know I could later. How
How much do you make there?
maybe 18 bucks. 18 bucks.
You have kids?
Yes,
How many?
one, but I take care of everything in my household.
So you can pay that, can you pay 50 more per month on this one?
So 100 a month total.
Well, if you're paying 55, yeah, that'd be 105. Can you do that?
I can make that happen.
All right, 50 per month, beginning May the 15th. Can you do that?
Yes, sir.
Or you want me to give you a little more time? How about May 31?
End of May.
May 31.
Yes, sure.
Here, the judge begins exposing exactly why he's upset. He reminds the attorney that he had already refused to adjourn the trial, yet somehow an order requesting that same adjournment still landed on his desk. From the judge's perspective, this feels like an attempt to go around his authority. You can hear frustration building as he questions not just the action, but the judgment behind making that move in the first place.
I know you have to pay on that particular case. So go down the hall, please. Austin J. Doyle, 26W8419318. Did you send that other file down with John yet, Heather?
No, I have it sitting here. He hasn't been down here.
Okay, can you, okay. Your name?
Austin J.
All right, you're charged with driving on a suspended. I can arraign you, send you to the prosecutor, or I can give you a lawyer.
Give me a lawyer, please.
Sure. I'll give you a lawyer. And you have a second charge of obstructed vision. Heather, can you have somebody run that down, please?
Yes, Judge, I have someone bringing it down right now.
Go out there. If he's gonna set you up with a lawyer, you can go right outside in the hallway, okay?
Thank you, John.
Thank you. Ed A. Manson Sons, Inc., 26W842464. That name, sir?
Eric Conley.
And I can't let you appear on behalf of a corporation on a misdemeanor. I'm sorry. You're gonna have to get a lawyer. I'm not trying to make money for lawyers, but that's just the rule on a criminal case. So I can't do it. I can give you an adjournment, but you're gonna have to hire a lawyer, okay?
Sir.
It's not my rule. It's the state's rule. The court's rule, whatever you want to call it. Mark, May the 13th. Is that at 8:30, Heather?
Yes, we could do 8:30.
I'm sorry, it's your first name is
Eric.
Eric. And that's TR1BLEY, right?
Yes.
Thank you.
Okay.
You're all set. Thanks. Mr. Knight, you and I are going to talk.
I know, Judge.
I'm not happy.
Not.
Eric Tarenti Bagaya, Jr., 26F262289. Your appearance?
Oh, Judge, Patrick Ryan, P76.
Oh, this is the one.
Tomorrow.
Yeah, I know. This is the one. I want you up here. Your appearance.
Patrick Ryan, P76343. Sorry, Judge, I was very confused.
Well, I called it because I got the stipulated order adjourning bench trial.
Correct.
I had told you last time I was not going to adjourn the trial.
I understand.
Why in the world would you do that and submit that with the hopes it's going to get by a judge? Either that or you thought I was kidding.
No, Judge.
I don't kid in here. I have a very good sense of humor outside of here, but I told you I wasn't going to adjourn this. And then I get a stipulated order, like I sign 150 to 200 orders a week, probably in judgments. Why would you submit an order, a stipulated order adjourning a bench trial when I just got done telling you I wasn't going to adjourn it? I hope you don't do that in other courts.
Judge.
So listen to what I'm telling you, counsel. I am not happy about this. I don't fool around in here. I'm not kidding. You guys had multiple pretrials. And now all of a sudden there's this urgency to adjourn because your client is going to start a job. If you had a pretrial on February the 5th, 19th, 16th of April, February 5th and 19th and March 19th and April 16th. And now you're telling my clerk your client's not showing up and you want to know when you can walk them in? Listen to me very carefully.
Now, the pressure reaches another level. The judge repeatedly asks one simple but powerful question: why would anyone do this after being told no? His tone makes it clear this isn't just about paperwork anymore. It's about respect for the court. The attorney starts defending his client, but the judge remains locked in, showing everyone that courtroom rules are not optional and attempts to bypass them won't be taken lightly.
If he dares plays games with me like that, he better have a lot of money. And don't think if you walk in here on Monday or Tuesday or Friday that I'm going to just say, oh, let's let bygones be bygones. He will be sitting in that lockup unless he's married to a physician for the longest time. But more important, I'm disappointed in you. When I tell you I'm not going to adjourn something, you don't submit a stipping order to adjourn behind my back with the hopes I'll forget about it and sign it. I'm serious as a heart attack. Why would you do such a thing?
Mr. Voglia asked me if I could do whatever I could to get it.
You brought it up. I said no. Why would you do such a thing? I don't care what your client asks you to do.
Judge, he finally got it before. He has 2 weeks where he can't.
This is an animal violation case. It's a dog bite.
It's a domestic violence, Judge. And they're going through a custody issue, so that's why we were trying to get it so the custody issue would not affect his.
You mean to tell me if he starts one day later, he can't get a job at Ford Motor Company?
Judge, the email said that he has to be there for 2 weeks straight. Otherwise, he will be terminated from the job. There's no exceptions, no excuses. Lee,
When is he supposed to start?
he started on Monday, Judge, so I think he's gonna miss work tomorrow and have to reapply to Florida.
Listen. I thought it was an animal violation, but it doesn't matter.
Now, did you,
Well, why so many? This is a domestic violence case. That's fine. But why so many pre-trials? If you guys needed to push this through, I'd have given you a trial date 6 weeks ago.
This is where the emotional side of the case starts to surface. The attorney explains that the client isn't trying to delay for no reason. He's dealing with custody issues and desperately trying to keep a new job that could support his children. Suddenly, the situation becomes more human. What looked like a procedural mistake now feels tied to real-life struggles, and the courtroom energy begins shifting from confrontation toward understanding.
Judge, we didn't want to push this through. We wanted to work with the family law to get their custody issues set up at the same time as this was being resolved. And they were supposed to have a custody hearing last week, and it's been a contentious issue. So, and he wants to be able to support his 2 children with the victim. He was a former police officer,
I don't care who he was.
and he lost his job, and now he's been working as a plumber, but he's like, I finally have a job to get in at Ford. I can't leave my kids and move some other because.
I know, but if he told you that,
Judge, I begged him to set it. I said, can you start 2 weeks later?
listen to me. If he told you that, and me, I vaguely remember you saying something about starting a job. Maybe you brought this up.
I don't believe I did, Judge, because I didn't know. He said he was looking for a job. He was waiting out for it to get back to it, but I don't know if I brought that up. I did bring up that he had custody. I wasn't trying to sneak anything by the judge. I just.
No, but you can't do this. I was really surprised. I didn't think you would do something like this. I mean,
Well,
you could have filed an emergency motion then and it been explanatory. It said this, that, and the other. All I've heard is adjourn on this case. I don't want to cost anybody a job. Heather, I'm going to forget that Mr. Nienhouse handled this inappropriately.
Judge, I take full responsibility.
Hang on. I'm going to adjourn this. You called Mr. Cayley's office. They already submitted a stip order. I'm going to adjourn this 2 more weeks. Is that going to do it? May 14th?
And here comes the big twist. After all the frustration and sharp criticism, the judge softens. He decides not to punish the mistake and instead grants the adjournment. But he makes one thing clear. Next time, do it the right way. This moment shows something powerful about the judge. He's tough on procedure, but still willing to show fairness when genuine hardship is involved. Authority and compassion meet in one ruling.
You sure?
Yes, Judge.
Because you said he started this last week and he needs to be there for 2 weeks, right?
He told me it was 2 weeks. He can't. I was like,
All right, okay, fair enough. For some reason, I thought this was an animal violation.
No, Judge, this was a,
We're gonna adjourn this to, or is it May the 13th, Heather? No, May the
No, because
14th.
it'll be May 14th, Judge. Do you want to
And
do it
I'm here
at
that day,
11
right?
o'clock? Yes, you are.
What time are we gonna do this?
Do you want to do
Judge-
11? Are we doing it as a trial that day?
Yes.
So you want
What?
to do 11 o'clock?
What?
I was gonna say, I have a Dearborn at 8:30 in the morning, so if I could just have it after 9:30 or 10.
I'll make it 11. May 14th at 11. I'm gonna forget this happened, by the way. Next time, file a motion, emergency motion. I'll accommodate you with an emergency motion, but I felt like you were trying to get one by on me, and I don't like that.
No, Judge, as soon as I got information from Mr. Bogia, I reached out to Mr. The APA,
May 14th, that's what we'll do.
and I was like, told him what's going on. I was like,
All right, good enough, good enough. No sense groveling any further, but I was disappointed in you. That's all I'm gonna tell you. It's forgotten. People against Buddy, or Bradley. Brianna Mae Bradley, 267-841-845, A and B. Now, what is the situation with this? Ma'am, come on up here and state your name, please.
I'm Brianna May Brad.
So the prosecutor's just dismissing. Is there a reason for it?
Yes, Judge, we found out later on there were co-defendants after I filed my appearances because they just got 2 separate tickets. The co-defendants taking full responsibility for this, and Miss Bradley was, based on the video evidence, was trying to break up the incident.
Okay, so for purposes of arraignment, she stands mute. Wait,
Yes.
full reading. Dismissed motion of the prosecutor.
No.
So he's saying that he's going to go ahead and just, because the co-defendant, Mr. Bradley, is going to take responsibility, right?
Yes,
Okay, good enough. Case dismissed, Nolly Prost, motion of the prosecutor. Ma'am, he is dismissing without prejudice. I'm not saying he can't,
A new case begins, and once again the judge immediately spots something others missed. As the plea agreement is presented, he catches a legal issue in the sentencing structure. While everyone else is moving forward, he stops the process and points out the technical error. This moment highlights how sharp and detail-oriented he is. Nothing slips past him, proving why every word and every legal step matters inside a courtroom.